I'm John Yanni, partner with Early Bird Venture Capital's Health Fund, and with me today is Peter Finney, who is a patent attorney from Potter Clarkson in the UK. Peter, we're going to share some of our war stories now, right? Because we've worked together now for many years, both as my patent attorney for some of my startups over the years, and also now you help with Early Bird and the due diligence. And what I'd be interested in is to talk a little bit about some of the most common mistakes that startups make when they enter into the process. And perhaps we can share some real world examples without mentioning names of things that went right and things that didn't quite go so well.
Yeah, absolutely. There's no fun in not mentioning names, but I expect I'll have to keep all of this anonymised, shall we say.
Indeed.
I think, again, when we're talking about due diligence, we're trying to stress test the truth behind somebody's position that we have some great technology, we're going to take X% of this huge market, and you're going to make 20, 30-fold return on your investment, John. And they build this expectation that they have technology that's protected, because we understand that's key. And what we find when we look at the patent applications is that they actually don't map to what they say they're going to do. To the extent they do, it's not described properly, that they're not going to get patent protection. Potentially that they also haven't done searches, so they've got no basis for making these exaggerations about the importance of their intellectual property. And we've revealed that on several of the exercises we've worked on, and in fact other ones that I've done, where once that position has been undermined, like a house built on sand, the foundations built on sand, there's only one way that pre-money valuation's going, is down. Potentially it's a deal breaker, showstopper. And it's relatively easy on due diligence to get to that point quite early on, and can lead to a huge loss of confidence in the end of the deal. But I've had several examples where there's going to be total exaggeration about the intellectual property position and no basis for it. And it's clear that the patent attorney that worked with them was very much working at arm's length, so didn't understand the business, so it wasn't reflected in the patent application and the disclosure. Do you know what it was done for, John? It was to say that we have a patent application to impress upon you that they have intellectual property. In fact, they haven't got one, they've got dozens. And we're not impressed by that, are we?
No.
Not at all. That's the sort of bad side of things, but you want to see, as we have, what happens when someone is in the opposite position, that they've said intellectual property is important, they've articulated the innovation that's relevant for the investment and the technology, and then you read the patent applications. It's like the tin, the label, it does exactly what it says on the tin. You look at their intellectual property and it maps very well to the business, and you get through that phase one of the due diligence really quickly. We had a great example of that where we were on the other side. We were working together for one of your companies. We came into a due diligence process. I wouldn't say they were hostile, but they weren't exactly friendly, and they thought that the intellectual property that we had developed wasn't that strong, didn't they? Well,
I think the view from that patent attorney who was doing due diligence for my investors or potential investors at the time was that you probably won't be able to protect this technology.
Yeah, and that was his position, and that's what he advised the investors.
But we proved him wrong, didn't we?
Well, because we were prepared. We had filed the patent applications with a strong understanding of the prior art, with a clear articulation of the invention, and that mapped to what we said we were going to do in the business plan and the investor slide deck. So we were able to rebut those assertions or allegations that we weren't going to get protection And it was a thing of beauty several years later, of course, when we were proven true. It was proven to be proven right, and we got our first US patent granted with the claims that we said we were going to get granted.
Indeed, and I remember sending the guy, who will remain nameless, an email informing him of that at the time. But having said that, the investors did actually invest in the company.
They did, yeah. Yes, no, that was great. I have seen tens of millions knocked off the valuations, pre-money valuations for startups because of an over-exaggeration of the IP position. And they've built their whole position that we've got intellectual property. We are going to dominate this market, almost as if you had a standard essential patent. Everyone's going to have to take a license. Again, the valuation is only going one way if that's not true. So I would beware of really building your entire proposition around intellectual property. It's so much more than that, isn't it?
Indeed. What about situations where you find that the company hasn't actually patented their invention at all? Are there any cases where that's occurred?
I've had several. Actually, they think they've patented it. They delegated to somebody else to file some patent applications, and it didn't describe the technology well. They, nevertheless, as far as they were concerned, patent pending, tick.
And the invention wasn't. The
invention wasn't there.
Wasn't there. Yeah.
And then we find, in the meantime, as part of either fundraising or just PR, they've actually disclosed the invention, the real invention. And at which point, well, what's the answer to the question, have you got innovation that you can protect? Well, we did. We don't now. Mm-hmm. And that will be a showstopper. And I've encountered a couple of those, absolutely. And that is a failure to manage the intellectual property properly. The companies paid lip service to it. It was just a tick box exercise to impress the investor that they had done something. The other type of common mistake is in FTO. So I've expressed to you many times, I'm not a great believer in FTO because I don't think it really means that you have absolute freedom. It's a question of how much money you spent, which markets you looked at. You could spend 5,000 on FTO. How is that the same as a £50,000 FTO exercise? It's not. So it's a limited form of risk assessment. That's all it really is. And it goes out of date very, very quickly because it assumes, of course, that you have frozen the design of your technology, which is unlikely for a startup. But equally, to be an ostrich with your head in the sand about it is unacceptable. And it becomes increasingly unacceptable as you go through further rounds because you're having to do warranties about the state of the company and the risks, and you can't, indemnities even, you can't give them because you haven't done any searching. But I think the worst errors I've seen is where people know, because of their backgrounds, who the key competitors are, and that they're likely to have intellectual property. And for one reason or another, they haven't gone on to Google or a Spasnet and put the name in and revealed that they have a patent that maps exactly to what they are doing. And I think that's criminal in many ways because it was a known risk. It wouldn't have taken very much to find it. And when that's found during due diligence, that can be very disconcerting. And of course, at that stage, very, very expensive to sort out. And it's not formally part of the due diligence process to actually do freedom to operate. It's to establish, a measure of that risk. But yeah, I've seen deals fail where companies have taken a very cavalier attitude to other people's intellectual property. Because again, it's a proxy. How are you going to act in 2 or 3 years' time when we're seeking more money and we get sued? And we have a great example of working together where we were under the radar for years until we got 30 million of investment from a major US corporate. We got a letter the following day. Suddenly we got a threatening letter. Yeah. I was really very proud of that because you'd arrived. You've arrived and you're important to somebody. But we also we often talk about patents, and they are very important in medtech and digital health, of course, particularly when there's a relationship with the pharma value chain. But companies often neglect their know-how. And they haven't taken steps to secure that and keep that secret. They haven't got a register. And if you look ahead to an exit, managing that form of intellectual property is every bit as important. usually at an early stage it can be fixed, but we're looking to see whether the company has a strong policy on protecting its secrets, and if it's been licensed in from a third party, that you've really understood what you've been licensed under that agreement.
Actually, that brings to my mind situations that can be quite complex, which is university spinouts and the IP associated with those. I mean, what can you give us a couple of your university spin-out war stories?
Well, universities, for various reasons, like to hedge. They need a vehicle for you to invest in. The key asset they're bringing, well, there are two really: people, obviously, but intellectual property. And so what they will typically do is license the company, an exclusive license, and there may be other terms to do with that. And so you're investing in a company that may not own any of its own intellectual property at that point. And what we're looking to see is whether there are clauses that will allow that intellectual property to be assigned into the company at a later stage, or whether it's absolutely forbidden under the university policy. Because for an exit, if I'm the acquirer, I don't want to buy a company that's got a license from university. It limits my ability to use the intellectual property to its full extent. But we also see this mixed loyalties, where there's a startup spin out from the university and the founders are still employed by the university, at least on some part-time basis. That creates issue over ownership of intellectual property, because normally it'd be the employer. Now you've got two masters, and you can't have two masters in IP terms, and the agreements don't cover it. So it can be messy. That's not true of all university spin-outs, but there's usually, we're not supposed to use this term in the legal world, there's usually a bit of laundering to be done to get the intellectual property a bit cleaner, so that you can understand the clearly divisible lines between who owns what's licensed, and what the company is going to own later on. And again, if we find that the attitude is skewed towards the university, that this is just a vehicle for you to put your money in, no, that can be a showstopper too, because again, it goes to the long-term relationship we've talked about that needs to be established with the investor. Again, going back to other forms of intellectual property, sometimes, not always, but sometimes, these technologies are very much consumer-led, so they need a good name, and that means having a trademark. Choosing the wrong trademark can actually be really expensive, because it might take years before you surface and attract someone's attention on a patent infringement. Start using the wrong trademark and get a domain that infringes someone else's trademark. You will get letters before action really quickly. And the money you spent developing your website and all your marketing materials will all be to waste, because you didn't do clearance searches, that form of freedom to operate for trademarks, where you check that you aren't infringing some third-party trademarks. You also want to choose a name that actually is registrable, not just descriptive. And that, again, is an element that's often misunderstood and not given priority.
Oh, well, it's very interesting. We shouldn't forget trademarks, because that's an essential part of this. What about on an ongoing basis? Do companies tend to have ongoing watches on what's out there? Is that something that you would recommend? Because it's important to keep your finger on the pulse of what's happening in your particular field.
Yeah.
And I get the impression from my experience that a lot of early stage companies don't actually do that as well as they should.
No, it's the databases are out there. They're free to use. I always recommend keeping a watch on publications, either in your technical field, if it can be defined fairly narrowly, and or in relation to names of competitors or names of inventors that are active. Because it comes back to the FTO position. What's your knowledge of FTO? I don't believe we infringe any patents, will be the answer. And the reason for that is we've never looked. That is not an answer that can persist much beyond level one of due diligence and investment. Angel investors don't look at FTO, but it's not credible for a VC not to at least ask the question and see the state of knowledge. Doing your own watches allows you to keep a perspective of what other people are doing, and will give you commercial insights of the sorts of risks you might encounter. Once you know them, of course, you have to disclose them. And that's why I think people don't do it to some extent. They don't want to know because then they might have to disclose it. But there's only so far you can go down the investment process by answering in that way. Watches on competitor patents is a really cheap way of doing it and gives you a credible answer to your approach to FTA. Yeah, we maintain a watch of the key competitors. It's always possible that some small company or lone inventor somewhere has filed a patent application that's relevant to what you're doing. But the main risks are going to come with competitors, because if you're right about your business, you'll nick their business. And they'll look to their IP to see if they can do something about it.
Indeed. Well, thank you, Peter.
My pleasure.
And thank you, everyone, for tuning in.